If your child was born in the United States, your green card case is waiting. Your TPS is from Haiti or Syria, or you are worried about cooperation with local police, the first week of July 2026 brought 3 major official updates that can affect your family, your work, your travel plans, and your next immigration step. As of July 6, 2026, these updates are not the same type of news. One is a Supreme Court decision on birthright citizenship. One is the official July 2026 Visa Bulletin, together with USCIS filing chart guidance. One is a Supreme Court TPS decision, followed by short-term USCIS and E-Verify document guidance, while enforcement continues to expand local partnerships. That means some people may feel relief, some may face delay, and some may need urgent planning. In this video, I will explain what changed, who is affected, who is probably not affected, and what you should check before you file, travel, work, or make a big immigration decision. Here at Smart Retirement Life, the goal is simple. We take serious immigration news and explain it in clear words, without panic and without false hope. Let us begin with the update that many parents were waiting for. On June 30th, 2026, the United States Supreme Court decided a significant case about citizenship. This was a court decision. It was not a proposed rule. It was not a bill in Congress. It was not a new law signed by the president. The case involved an executive order signed on January 20th, 2025. That order tried to limit U.S. citizenship for some children born in the United States when their parents were unlawfully present or only temporarily present. The Supreme Court held that children born in the United States to parents who are unlawfully present or temporarily present are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment. The 14th Amendment is the part of the Constitution that protects citizenship for people born in the United States and subject to U.S. jurisdiction. Here is the plain meaning. If a child is born in the United States, the child is still a U.S. citizen at birth under this decision, even if the parents are undocumented or in temporary status, such as a student visa, work visa, tourist visa, or visa waiver program travel. Before this case, most families understood the basic rule this way. A child born in the United States was normally treated as a U.S. citizen at birth. There are narrow exceptions, such as some children of foreign diplomats, but for most families, a U.S. birth meant U.S. citizenship. The executive order tried to change that rule for certain children based on the parent's status. Lower courts had blocked the order before the Supreme Court gave its final answer on the constitutional issue. Now, the Supreme Court has rejected the main legal argument behind that order. But this is where many people become confused. The ruling protects the child's citizenship. It does not give the parents automatic legal status. It does not give a parent a green card. It does not cancel a deportation order. It does not erase an overstay. It does not fix a missed court hearing, a fraud issue, a criminal issue, or an old removal case. Imagine a visitor named Daniel. This is only an example. Daniel and his wife are in the United States on temporary visas and their baby is born in Texas. Under the Supreme Court decision, the baby is a U.S. citizen at birth. But Daniel and his wife still need to follow the rules of their own visas. They still need to check their I-94 records. The I-94 is the entry record that usually controls how long a person may stay after being admitted to the United States. So the first message is good news for many families, but it must be understood correctly. Birthright citizenship is protected by this decision. Parent status is a separate issue. Before you make any decision, keep the child's birth record safe. Save the hospital record, birth certificate, passport record, and any official notice. Do not panic because of old social media clips saying birthright citizenship ended, but also, do not stop protecting your own case just because your child is a citizen. Now, let us move to the second update where many green card applicants may face the biggest timing problem. The Department of State issued the Visa Bulletin for July 2026. The Visa Bulletin is the monthly chart that controls many family-based and employment-based green card cases. A green card is lawful permanent residence. It allows a person to live and work permanently in the United States, unless that status is later lost or taken away through a legal process. The Visa Bulletin does not approve your case by itself. It tells you when a visa number may be available based on your category, your country, and your priority date. Your priority date is usually the date when your family petition, labor certification, or immigrant petition first started. Your country of chargeability usually means your country of birth, not always your current passport country. For July 2026, USCIS says family-sponsored preference applicants inside the United States should use the Dates for Filing chart. Dates for filing means the chart that may allow some people to send documents earlier. USCIS says employment-based preference applicants should use the Final Action Dates chart. Final Action Dates means the chart that normally controls when a green card can be approved or an immigrant visa can be issued. This difference matters because filing and approval are not the same thing. For family cases, the F2A category is important. F2A means spouses and unmarried children under 21 of green card holders. In the July 2026 Dates for Filing chart, F2A is current for all countries. Current means there is no cutoff date in that chart. So, some F2A applicants inside the United States may be able to file Form I-485 if they meet all other rules. Form I-485 is the Adjustment of Status application. Adjustment of status means asking for a green card from inside the United States. But the Final Action Dates chart tells a different story. For July 2026, the F2A final action date is January 1, 2025 for most country groups, including China, India, and the Philippines. For Mexico, the F2A final action date is January 1, 2024. That means some people may be allowed to file, but their final approval may still have to wait. This is a common mistake. Someone hears that F2A is current and thinks the green card will be approved right away. That may not be true. In immigration, the right to file today does not always mean the right to be approved today. Now let us look at employment-based green cards. This is where the July Bulletin creates serious delays for some applicants from India. For EB1 India, the July 2026 final action date is October 15, 2022. EB1 is a category for certain priority workers, including some people with extraordinary ability, outstanding professors or researchers, and multinational managers. For EB2 India, the July 2026 final action date chart shows unavailable. EB2 is often used for people with advanced degrees or exceptional ability. Unavailable means visa numbers are not authorized for that category and country for that month. The Department of State also says EB2 India is unavailable for the rest of fiscal year 2026. The fiscal year ends on September 30th. For EB5 India, unreserved, the category is also unavailable for the rest of fiscal year 2026. EB5 is the investor green card category. Unreserved means the regular EB5 group, not the special set-aside groups for rural areas, high unemployment areas, or infrastructure projects. The bulletin also warns that EB2 China may retrogress or become unavailable. Retrogress means the date can move backward. It also warns that EB3 Philippines may retrogress or become unavailable if demand stays high. Imagine an engineer named Priya from India. This is only an example. Her employer filed an EB2 case years ago. She sees someone online say July is good for green cards. That statement may be true for some people, but it is not true for EB2 India final action in July 2026. If Priya's adjustment case is pending, her case may not be denied, but it may not be approved while visa numbers are unavailable. Here is what this means for you. Check your exact category. Check your country. Check your priority date. Check whether your case is family-based or employment-based. Then check which USCIS chart applies for July 2026. Do not use a screenshot from last month. Do not assume your friend's case has the same facts. Also remember this important difference. A visa stamp and lawful stay are not the same thing. A visa stamp helps you travel to a U.S. port of entry. Your I-94 normally controls how long you may stay after admission. USCIS handles many immigration benefit applications inside the country. The Department of State handles visa processing at embassies and consulates. CBP handles inspection at airports and borders. These agencies do different jobs. Now we need to talk about the third update. This one may be the most urgent for some TPS holders and their employers. On June 25, 2026, the Supreme Court decided an important case about temporary protected status. This case involved temporary protected status for Haiti and Syria. TPS is a temporary protection for people from certain countries when conditions in that country make return unsafe for a period of time. TPS may protect a person from removal and may allow a work permit, also called an EAD. But TPS is not the green card. TPS does not automatically lead to citizenship. The Supreme Court did not create a new TPS program. It did not decide that every person from Haiti or Syria has the same case. It decided that people challenging the TPS terminations were not entitled to court orders postponing the terminations during the litigation. In simple words, the court gave DHS a stronger path to move forward with the termination decisions. For Syria, DHS had published a termination date of November 21, 2025. For Haiti, DHS had published a termination date of February 3, 2026. Court orders had delayed the effect of those terminations. After the Supreme Court decision, USCIS and E-Verify issued short-term guidance for documents and work verification for certain TPS-related work authorization documents. The guidance points employers to July 10, 2026 for Form I-9 and E-Verify purposes. Form I-9 is the work authorization form every U.S. employer must use. E-Verify is an electronic system some employers use to check work authorization. This is the key point. July 10th should not be treated as a full long-term TPS renewal. It is short-term document guidance while courts and agencies take the next steps. More guidance may be issued. Imagine a Haitian TPS holder named Marie. This is only an example. Marie has worked in healthcare for years. She sees one post saying, TPS ended immediately. Then she sees another post saying, TPS is safe because of July 10th. Both posts may leave out the most important detail. Marie needs to check her country page, her EAD category, her card expiration date, any automatic extension notice, and any new USCIS or E-Verify update. If she has asylum, a family petition, an employer case, or a prior removal order, her situation may be very different from another person's situation. This TPS update also connects to enforcement concerns. ICE has continued expanding 287G agreements. A 287G agreement allows certain state or local law enforcement agencies to perform some immigration functions under supervision. ICE reported more than 2,000 such agreements, covering many states and 2 U.S. territories in early July 2026. This does not mean every police officer is ICE. It does not mean every immigrant will be arrested. But it does mean that in some places, local contact with law enforcement may carry more immigration risk, especially for people with prior removal orders, criminal arrests, missed court hearings, or no current protection after TPS ends. Now let us look at who may be affected first. Families with U.S.-born children are directly affected by the Birthright Citizenship decision if the child's citizenship was questioned because of the parent's unlawful presence or temporary status. The child is protected by the Supreme Court decision. The parents are not automatically protected. Family-based preference applicants may be affected by the July Visa Bulletin, especially F2A spouses and children of green card holders. Some may be able to file under the dates for filing chart, but approval depends on the final action date and all other eligibility rules. Employment-based applicants from India may feel the strongest July delay, especially EB2 India and EB5 India unreserved. EB1 India applicants also need to watch the date carefully. Applicants from China in EB2 and from the Philippines in EB3 should watch for possible future retrogression. TPS holders from Haiti and Syria are directly affected by the Supreme Court TPS decision and the short-term work document guidance. Employers with TPS workers also need to follow official Form I-9 and E-Verify instructions. Other TPS countries may have their own court cases and agency updates, so do not copy another country's rule. The biggest hidden risk is making a decision from only one sentence online. One person may be safe to file. Another person may not. One person may be able to keep working under short-term guidance. Another may need a lawyer because of a prior order. One person may have a U.S. citizen child, but still have an old immigration court problem. The practical plan is not complicated, but it does require care. If your concern is birthright citizenship, protect your child's records. If your concern is a green card, compare your category, country, and priority date with the correct July chart. If your concern is TPS, save your TPS approval notice, EAD, passport, I-94, court papers, and any pending application receipts. If your employer asks about work authorization, ask them to follow official I-9 and E-Verify guidance. Keep your address updated with USCIS. If you are in immigration court, keep your address updated with the court as well. These are separate systems. Updating one may not update the other. Do not file a form only because someone on social media told you to. Do not assume another person's case has the same facts. Do not miss an official deadline while waiting for another announcement. Do not send false information. Do not use fake documents, a fake address, fake employment, or a fake marriage. A false answer can create a much bigger immigration problem. Now, let us correct 3 rumors. Some posts claim birthright citizenship has ended for children of undocumented parents. That is false. As of July 6, 2026, the Supreme Court protected citizenship at birth for children born in the United States to parents who are unlawfully or temporarily present. Some posts claim every green card case is frozen in July. That is false. Some categories are current, some can file, some are delayed, some are unavailable for certain countries. The answer depends on category, country, priority date, and the correct chart. Some posts claim July 10th is a full new TPS extension for Haiti and Syria. That is not the safe reading. Current guidance uses July 10th for work document and verification purposes, while court and agency steps continue. TPS holders should keep checking official updates and should not assume long-term protection unless DHS or a court clearly provides it. Here is the balanced message. Many viewers are not facing the same risk at the same time. A Supreme Court win on birthright citizenship is important, but it does not solve a parent's case. A Visa Bulletin delay is painful, but delay is not the same as denial. A TPS court decision is serious, but your exact risk depends on your documents, other applications, court history, and future guidance. Here at Smart Retirement Life, we want you to act from facts, not fear. Good records, early planning, and correct dates can help you avoid problems that did not need to happen. Immigration rules can change, court orders can change, agencies can issue new guidance. This video reflects information available as of July 6, 2026. It gives general information only. It is not personal legal advice. Every case has different facts. If you have a deadline, arrest, removal order, denied case, court hearing, travel plan, fraud issue, criminal history, or official notice, speak with a qualified immigration lawyer or an accredited representative. If this video helped you, like it, share it with someone who may be affected, and subscribe to Smart Retirement Life. Comment with the immigration category you want explained next, but do not post receipt numbers, alien numbers, passport details, addresses, dates of birth, full legal names, or private case documents. Keep your papers safe, check the real dates, and make your next immigration decision with calm, careful planning.